Hello and welcome to the very first edition of Canadian HR Law, a monthly show dedicated to addressing issues of employment law and HR. Every month we're going to have a review of recent developments, followed by an interview with someone from the world of HR, and finally a topic that's near and dear to my heart, a Just Cause Roundup, where we look at cases of summary dismissal. My name is Stuart Rudner. I'm a partner with the law firm of Miller Thomson. I have a practice focused on employment law, and our guest today on our first show will be Pressman from References and More Services. So on to the review of recent developments. There's three recent cases that I want to talk about, each of which should sound an alarm bell to employers in their own way. The first one is a case involving bad faith damages. And if employers thought they were off the hook when it came to bad faith as a result of Honda Canada and Keys, they should think again as a result of the decision from the Alberta courts in Soust and Merrill Lynch. In that case, Merrill Lynch was found to have acted in bad faith when they dismissed Mr. Soust, and the court awarded $1.6 million in what I usually call the damages formerly known as Wallace. That's a far cry from the 2 or 3 month Wallace bump we used to see when bad faith was found. The second case I want to mention comes out of the Ontario Human Rights Tribunal. In that case, a woman who joined a trucking company was subjected to derogatory slurs regarding herself and her husband, and ultimately she was fired when she took 2 days off to go to Sick Kids Hospital with her son. Ultimately, the tribunal found that there was discriminatory behavior. They awarded her just under $32,000. $25,000 of which was for the inappropriate behavior. The rest was for lost wages. Finally, this week, the Ontario Supreme Court certified a class action in a case against Ford where the allegation is that Ford made offers of employment and then subsequently reneged on them. The class action has been certified, so it remains to be seen what will happen in the case, but it should serve as a warning to employers to be very careful about making offers and then rescinding them. That's the review for this month. Now we'll move on to a discussion with Pressman. Okay, well, our plan is to have a guest each month, someone from the HR world who will bring a perspective that's different than mine with respect to HR and employment law issues that HR professionals and businesses are facing day to day. So our very first guest is Pressman. Claire is with References and More Services, which is a pre-employment screening firm focused on performance-based reference checks and also exit interviews. So Claire, not surprisingly, what I want to talk about is references, both getting them and giving them. First of all, what would you recommend to organizations that are looking to hire someone and have to deal with checking references and background?
First of all, my first recommendation is absolutely do the references. It is a very important part of the recruitment process. It's the last step. And you have to look at the quality of the referees. First of all, my first recommendation is absolutely do the references. It is a very important part of the recruitment process. It's the last step. And you have to look at the quality of the referees, the people who give the references as well. You need to make sure that it's not a personal reference, not a parent, not a family. Someone that you have worked with, preferably at least one supervisor, a colleague, a client, and that would give you a very good 360 on the reference. Next, when you do the references, ask open-ended questions,
Great, and you've hit on one of the points that I've learned from dealing with my clients, which is that the reference letters, which I used to think were very important, may not be that valuable. And what I've been told is that it's actually calling and talking to people. That's where you'll really learn about the candidate.
Absolutely. I mean, the conversation is the best thing. First of all, this way you can control the conversation and you can get the information that you need to get about the candidate and the skills that the candidate has. And you can make sure if there's any issues or performance issues, you can listen to any hesitations in the person's voice, which you'll get.
Okay, and one thing I've encountered quite a bit is the fact that many organizations have either a no reference policy or a name, rank, and serial number policy where they just give you confirmation of the employment details but no positive or negative commentary. And I've spoken and written quite a bit on why I don't think that's a good policy in most cases. But what do you as a reference checker do when you come up against that?
It's very common, first of all, and it's a very big frustration because most organizations want to get references for their own candidates or incoming employees. But really, the onus is on the candidate. They should be aware of the company that has a no-reference policy. When we do a reference check that has a no-reference policy, we will speak to the referrer and say, if you have a no-reference policy, if they say they can't give references, we will ask if they'll do a personal reference after hours and say if there's anything that you're uncomfortable with, just don't comment on it. Usually, if the person likes the candidate, they will continue, they will do that, and they will offer their time after hours. If they refuse, it might be it might be a red flag.
Okay, and then other than checking references, what do you recommend that employers or potential employers look into?
It's very important, or it's a very good idea to do a criminal and credit check. As you know, you have to be consistent. You can't just do it for one person and not the other. But if somebody is going to be working with an organization's money or finances, you want to make sure that they're not in dire straits financially and have to resort to desperate measures.
Right, and one of the things you've mentioned to me previously is the fact that getting those criminal background checks can be quite an issue these days.
Well, there has been a change with the RCMP now. So if the candidate has been flagged with a criminal check, with a criminal offense, the report will say that they may or may not have a criminal offense, and the candidate does have to go to the police station and be fingerprinted, and that will take up to 120 days to get a report, which all of a sudden becomes an issue for the hiring managers.
And another reason why they shouldn't leave all these background and reference checks to the last minute.
You're right, and there should be process and policy.
Great. Okay, well, I think we're just about out of time, but thank you very much for being our very first guest.
And thank you for having me.
Those were some very helpful comments from Claire Pressman on the practical aspects of giving and getting references. One of the issues that came up in our discussion is the fact that many employers have a policy of not giving any references at all, or simply giving a confirmation of employment. For my 2 cents worth, in most cases there's no good reason not to give a reference, and in fact there would be very good reasons to give references to employees that you've let go. One of the reasons that I'm often given for not giving references is a concern about being sued. There's a concern that if you give a bad reference, you're going to be sued for defamation or slander, in which case what I would say is that as long as you're giving a reference honestly and in good faith, that should not be a concern. The other comment I've heard is that there's a concern about giving good references, in the sense that if you give someone a good reference, another employer relies upon that and finds that the employee isn't so good, they could turn around and sue for misrepresentation. What I can say is that I'm not aware of a single case in Canada in which a successful claim has been made on that basis. Conversely, there are usually very good reasons for giving references. If you're giving an employee working notice or some sort of package with salary and benefit continuation, hopefully you've structured it so that if they get a new job, your obligation either ends or is dramatically reduced. So you, the employer letting someone go, has a very real interest in seeing them get a new job. And if you can help them by giving them a reference or outplacement counseling or whatever the case may be, there should be a very real interest in doing so. So from my viewpoint, in most cases, it makes sense to give references. And as I said earlier, be honest, act in good faith, and where you can, so simply avoid the bad topics and focus on the positive. Moving on to the Just Cause Roundup. For our first episode, what I wanted to talk about were some recent incidents involving the TTC. Many of those in Toronto and Ontario and perhaps around the country are aware of the first incident where a TTC collector was snapped taking a nap in his toll booth or his collection booth, and subsequently a couple of bus drivers were videotaped stopping the bus, getting off and attending to personal errands like getting coffee or going to the ATM. When I was listening to a talk show in Toronto, many of the callers took the view that as soon as you catch someone sleeping on the job, that's sufficient to get rid of them and fire them for cause. And the 2 points I wanted to make today were that anytime you as an employer suspect someone of engaging in misconduct, you have an obligation to engage in some sort of investigation before acting. Second of all, even if you do confirm that there was misconduct, such as sleeping on the job or stopping the bus to go get a coffee, you can't simply conclude that you have the right to dismiss them. The courts are very clear that you have to take what they call a contextual approach, which means looking at the entirety of the relationship, how long they've been there, what kind of a contribution they've made, whether they've been in trouble before, as well as how they respond to the investigation itself, and if they're honest and forthright in the investigation or if they try to cover it up. Then you have to take all of those factors into the mix and assess whether the relationship has been irreparably harmed, in which case you could summarily dismiss them, or whether some lesser form of discipline would be appropriate. So I guess the 2 points to take again are conduct the investigation, and simply because there's misconduct doesn't mean there's just cause for dismissal. So before we sign off on our first episode, I do want to encourage our viewers to get in touch with us if they have any questions, comments, or suggestions either on issues we've talked about, issues you'd like us to talk about in the future, or just any suggestions you have on how we can make the show better. You can reach us by email, Twitter, LinkedIn, or by telephone. One way or the other, you should be able to find us. So thanks for watching, and we hope you tune in again next time.